Hi, everyone, and welcome to another Darrow webinar. Today, we're going to talk about a new era of greenwashing litigation. Let's just give it a few more seconds to let more people join. It's wonderful to see familiar faces and new names. Welcome, everyone. Um, right, I think we can join. We can start. Um, so my name is Amit from Darrow, and today we're going to speak about greenwashing. And before we start, I'd love to introduce our speakers. I'm joined today by John and Noah. So John Stahl is a legal consultant here at Darrow, and he works with law firms on cases spanning a variety of causes of action, including obviously greenwashing and false advertising, privacy, ERISA, and more. John joined Darrow from Mayor Brown's Supreme Court and Appellate Group, where he worked on ERISA, class action, and mass tort matters. And prior to that, he held a bunch of other roles in the legal world. Hi, John. It's really wonderful to be with you today. And we are also joined by Noa Bradley, who is a legal intelligence analyst on our Enviro team. She has a dual bachelor's degree in law and environment science, which sets her up perfectly for success in her role. And prior to Darrow, she worked as a researcher in oceanography and geochemistry lab focusing on ocean-based carbon removal. These are all of the complex words I'm going to say for today. My name is Amit Shemesh. I'm going to be your MC, and I want to start with framing the conversation and speaking about climate progress with a question mark. Um, so what we can see here is the Fortune 500 companies that made a net zero commitment by 2050 with the aligned with the Paris Agreement. And clearly there is an increase, but a big question here is what is the nature of the commitment, and is it actually committing to net zero, or is it greenwashing, which is exactly our topic for today. And before I joined Darrow, I was actually an ESG attorney myself, and I was handling CO2 emissions for a German company. And I want to bring some of my favorite examples of greenwashing before we dive in and show how we at Darrow discover these kind of claims and then how we litigate them. So here are four examples, which many of you would know. The first one is, when you look up a flight and the airline says that there is X% less emissions, and the question there is, out of what? What's the baseline? And are these 16% actual cuts of CO2, or are they just offsets? And if they're offsets, what's the nature of what they're offsetting? Another great example is coffee capsules, with many of them being labeled fully recyclable, but then it might be in a very specific facility, or you'd have to email them back to the coffee producer, which basically makes it much more of a marketing thing, showing that these capsules could be recyclable versus the reality of the difficulty of actually recycling them. Um, then the fashion industry, which obviously is a big contributor to CO2 emissions, with a lot of labels of recycled fibers. And then the question is, what percentage is recycled? Oftentimes not disclosed. And then there's, on top of that, the question of what does go into production, which dyes are used, how much energy is used to produce the garment. And does that actually get to the consumer with that label that says that the garment is environmentally friendly, and obviously packaging, which says it's fully recyclable and will be recycled. And there are questions there. Many facilities, for example, do not treat boxes that are not clean. And then that means that most of our food takeaways are not, in fact, recyclable. All of these examples just go to show that whilst there are a lot of commitments to net zero, a lot of them are more of a marketing promise than an actual step towards being more environmentally friendly. Um, the nature of discovering and litigating these legal violations is challenging, mainly because it's difficult to quantify CO2 and to actually prove the nature of these claims. And then the other side of the coin is the very strong corporates that are most times behind these brands. And that is exactly what we're going to speak about today. We're going to talk about discovering these claims and discovering these legal risks and being able to assess them and understand what's the scope of them, and then the challenges and breakthroughs that are associated with litigating these type of claims. And on that note, join me in welcoming our first speaker, John.
Thanks, Amit. Just to reintroduce myself, my name is John Stahl. I'm a former litigator. Right now, I'm a legal consultant here at Darrow, and I've been following the case law, the greenwashing and carbon neutrality greenwashing case law very closely. So I'm excited to discuss that today. Um, in short, given that there's sort of limited government resources involved with enforcement, the responsibility falls on private actors and plaintiffs' lawyers to make sure that companies are not engaging in greenwashing and they're not flooding the market with sort of false environmental claims. I'm excited to discuss that here today. So, just a very brief explanation of what greenwashing is. Greenwashing is the practice of making false or misleading statements about the environmental benefits of a product or a company itself. Um, Query why companies do this, given that they open themselves up to false advertising liability potentially. It's because there's growing consumer demand, robust consumer demand for products and companies that hold themselves out as responsible stewards of the environment. Consumers care and they're willing to switch brands and they're willing to pay price premiums for environmentally friendly products. Also, there are ancillary benefits to companies that have sort of a good stated environmental record, including beneficial treatment from banks and from stock exchanges and the like. So there's certainly an incentive here for companies to engage in greenwashing, unfortunately. One of the particular areas of greenwashing that we're going to focus on today is carbon neutrality greenwashing statements, which effectively is a company saying either as a corporate level we're carbon neutral or our product resulted in zero net carbon emissions. Um, there's a whole host of sort of complexities when it comes to carbon neutrality statements because uh, in order to reach carbon neutrality, or allegedly, companies buy offsets from carbon projects located abroad, whether they be forestry projects, things of that like. And so it's very hard to sort of understand what the basis of a company's carbon neutrality statement is. And then once you even understand where the projects are, what the projects are, they're located abroad. There's not so much public disclosure about what's going on, which makes it very difficult for certainly a consumer and even a sophisticated plaintiff's attorney to figure out what's going on. And again, all this is problematic, particularly when these claims are false, because they take advantage of a consumer's preference and demand for a sort of an environmentally friendly product. So when a plaintiff suspects that sort of a carbon neutral claim is false, they can bring a lawsuit under sort of state law for false advertising under the laws of jurisdictions that are favorable to consumers, like California or the District of Columbia. But I want to focus here on sort of a couple buckets of issues that a plaintiff will face when strategizing, drafting a complaint, and ultimately litigating it. The first, of course, is case discovery. That is because, as I mentioned, these carbon offset projects that form the basis of a company's carbon neutrality statement, they're located abroad. There's not so much disclosure about them. It's hard to understand exactly what's going on, certainly without going over and investigating the project themselves. But, consumers don't have the resources and time to go to China, for instance, to actually see if the project is legitimate. And so there's a lot of costs with case discovery and there are just limited tools available. Related to that is evidence gathering because of sort of the far-flung nature of these projects and the technical nature of how they work and how the accounting is done. It's very difficult for a consumer or their attorney to really get a handle on whether or not the projects are legitimate and thus whether the carbon neutrality statement is false. A sort of third bucket of things that you need to be aware of are the statements themselves. Sometimes a company will make a completely unqualified carbon neutrality statement saying this product is completely carbon neutral. That is doesn't always happen. Sometimes there's fine print with disclaimers. Sort of what a company wants to build in a protection against liability, and so they'll have a big sign, "This is carbon neutral," and then in fine print, sort of try to walk it back, and that can be an issue in a sort of a false advertising case. The final thing I want to focus on right now is just plaintiff. So plaintiff selection in this context is very critical. In order to have standing and to have a claim, you need a plaintiff that can testify to the fact that they really cared about the carbon neutral statement. They bought the product because of the carbon neutral statement. They were aware of it, and those sorts of things. Without that, then you don't really have standing, and your case can fall apart. So it's very critical in the first instance to ensure that your plaintiffs are solid and that they could testify to the fact that these representations really mattered. Going into just sort of the common barriers we've seen sort of after a case is filed. Um, and we've seen this play out in a number of litigations that are ongoing, including a case against Apple involving carbon neutrality statements for their Apple Watch series, which I'll discuss more in a bit. These are sort of the four big arguments that defendants raise in their motions to dismiss, and certainly arguments that plaintiffs' lawyers need to be aware of when considering bringing a case like this. The first is Federal Rule of Civil Procedure 9B. These are false advertising cases. The claims sound in fraud, meaning that any complaint has to comply with the strictures of Federal Rule of Civil Procedure 9B. What that means in practice is that a plaintiff in the complaint needs to be able to describe with adequate specificity all of the circumstances surrounding their exposure to the false statement. That means when they saw the carbon neutrality statement, the circumstances surrounding it, how often they saw it, what time they saw it, what specific advertisement in a series of carbon neutral advertising campaign, which one they saw. Um, this sounds perhaps simple, but plaintiffs can just generally be aware through a wide-ranging advertising campaign that something is carbon neutral and may not specifically remember when they first saw it, what exactly they saw. And in some contexts, courts demand sort of a higher level of detail than perhaps is reasonable to expect of an average consumer. The second bucket is a very interesting doctrinal issue, third-party certification, and sort of how that relates with the Federal Trade Commission's green guides. In short, the Federal Trade Commission has regulations that outline what a marketer can and can't say when it comes to environmental claims. Defendants, and particularly the Apple case, they point to these green guides and say, if I complied with the green guides, then I have a safe harbor from state false advertising liability. The green guides, and these provisions of the green guides, have never been interpreted by courts before. This is teed up in the motion to dismiss in Apple. And so the court will sort of get to dig into the first time whether, for instance, under the green guides, having a third-party certification of carbon neutrality insulates a company from liability, even if the carbon neutral claim is ultimately false. The next barrier that we see in sort of the briefing is companies argue that their statements are not actionable, meaning that they're not actually false or misleading. This goes back to the point I raised earlier, where oftentimes carbon neutral representations have disclaimers and qualifications and those sorts of things. In short, companies in court want to walk back their carbon neutral representations and say, well, we didn't actually mean it quite like that. If you read the fine print, you'll know that we had some escape hatch here. And so that's just important to know when a plaintiff's lawyer is assessing whether to bring a case, just to really understand what the advertisement says and whether or not the defendant sort of bought that option with disclaimers and other things. The fourth thing that we've seen the motion to dismiss briefing, and that may pose an issue, is reliance. Again, this goes back to what I discussed earlier with plaintiff selection. In order to have a claim here, you need a plaintiff that relied on the carbon neutral statement when making the purchasing decision of the product or when deciding to pay a price premium for the product. And so what defendants will say is that, everyone, including your plaintiff, bought my product because of how technologically awesome it is, because it's better than the competitors. They'll say, the fact that it was carbon neutral could not reasonably have caused them to purchase my product because there are so many other cool things about it. That again, as I mentioned, means that you really need to find a plaintiff that can substantiate and credibly say, no, I really do care about environmental stewardship. I support companies that invest in carbon offset projects, and it was that was a major contributing factor to me deciding to buy the product. So again, these are all sorts of arguments that are percolating in the courts. Not all of them have been addressed yet, and going to my next slide, a lot of them will be resolved or at least addressed by the Northern District of California in the Apple case. So in the Apple case, Apple a few years ago rolled out a line of new Apple Watches and said that they are all carbon neutral. To substantiate that, they bought carbon credits from a variety of projects located abroad and retired those credits against the emissions of the Apple Watches, and then went out and claimed that the product is carbon neutral. So plaintiffs brought suit. They said they identified a variety of issues in the complaint with the four projects that underpinned the carbon neutral representations, and Apple moved to dismiss. Right now, the motion to dismiss is fully briefed. A lot of the issues I just discussed were teed up, and I just want to key in on one is the sort of green guides argument. This is a matter of first impression, how the green guides interact with state false advertising law in this specific context. Um, if the court adopts Apple's sort of very broad reading of the green guides, effectively, it doesn't matter if the statement is in fact false, so long as I had a third party certification saying that it was not false, then that would be a significant barrier to sort of follow on litigation against other defendants. If the court adopts the plaintiff's reading of the green guides, which says, listen, the green guides say that you need to do a whole host of things before making a statement, but it also critically says that the statement needs to be in fact true. So you can show me your third party certification, you could show me whatever you want. But if I'm alleging, and if I ultimately prove that your representation is false, then the green guides are of no help. So that'll be a very interesting decision to watch. And if it gets past motion to dismiss, certainly a very interesting case to watch as it goes through summary judgment, class certification, and so on. So I know we here at Darrow are following that, and I would encourage everyone interested in this domain to do the same. So that's all I have for right now, and I'm happy to throw it to Noah to discuss sort of the legal intelligence angle of greenwashing.
Thank you so much for this one, John. That was really interesting. And I agree, the challenges of greenwashing litigation are so unique and very hard to overcome. And this is extremely frustrating because there is so many companies making those green claims out there, but legal teams just don't have the tools or capabilities to challenge them. But that's why we at Darrow are very excited about climate intelligence and how it can be used to solve this problem. And that is what I'm here to talk about with you guys today. So hi everyone, my name is Noa Bradley and I'm a legal intelligence analyst in the environment team, leading the greenwashing space. So let's start from the beginning. What exactly is climate intelligence? So climate intelligence is the ability to collect, analyze, and apply environmental and climate-related data to develop meaningful insights. It's basically a combination of two main fields, which is the environmental data sources and the right technology. So we combine sources like air quality and satellite imagery and biodiversity data and weather pattern with technologies such as AI, machine learning, data science, and geospatial analytics. And although climate intelligence is broad, multidisciplinary field that's being used across many industries, from agriculture to finance, we at Darrow like to focus on its legal potential. In that sense, climate intelligence is sort of a substance of legal intelligence. It's the use of environmental data to support investigation, to substantiate legal claims, and to ultimately pursue climate justice. How this can be worked in practice. Let's take the carbon credits market, for example, which is the conversation of our talk here. The most useful tool and information we can use in order to evaluate carbon credits project, especially forestry one, is satellite imagery. Satellite imagery data and information allowed us to track forest change through time. So for example, if I have a carbon credits project that claimed to plant a certain amount of area with trees, I can verify that process with satellite imagery data. I can verify if those specific amount of trees that have been claimed to plant were truly planted. Or if I have a carbon credits project that is claiming to protect a forest, I can check using satellite imagery data if there is deforestation in that area and this forest is truly being protected. And climate intelligence doesn't end here with forestry project. We can actually use it in evaluation of much more type of project. For example, I can get data of wind intensity and to estimate using that data the potential of generating electricity from wind in a certain location. That helped me in evaluating a wind energy carbon credits project. And the same thing and with the same methodology can be used with solar energy project. Just in that case, we're using sunlight data and not wind data. So in short, climate intelligence is the use of environmental data and analytics to generate evidence-based insight. We take this complex environmental data and we turn it into actionable proof that can be later come into court. So like, what is the hype about that? Why we at Darrow are really excited about climate intelligence? We identified that it's basically changing the rules of the games when it's come to corporate accountability. Until not far ago, until the recent past, companies could have made freely sustainable claims as long as they want, and no one, and let alone legal teams, have the capabilities and the tool to challenge those claims and to evaluate them. This led to two main characteristics of how greenwashing litigation typically turned out in the recent years. The first thing is that there are very few cases that were filed at all. For the same reason and challenges that John was mentioning and talking about, those cases are hard to bring to court. But the second element of how those type of litigation usually turns out is that even if we had this litigation and plaintiff firms did take that to court, all those cases were lack of environmental evidence. Most of cases stay within the realm of consumer protection, presenting misleading advertising and claiming that terms that have been used are misleading. But none of these cases didn't include underlying environmental reality behind those products and claims. But this landscape is changing right now. We were following the recent wave of litigation of 2025, and we identified that plaintiff firms started to incorporate climate intelligence as evidence in their cases. We saw that in the Apple case that John was discussing on. The plaintiff firm there was basically using satellite imagery data and analytics in order to prove that the project that Apple has invested in did not actually achieve the climate impact they claimed to achieve. And we saw that in another litigation against Procter & Gamble, which the plaintiff firm there was basically showing that the sourcing of the paper that have been used in that product did suffer from deforestation, even though the company claimed it did not. So in like bringing those type of claims and evidence to the lawsuits are really raising the bar. So if courts and judges would have dealt with in the past with questions that stayed in the sphere of, is it reasonable to claim that this term is misleading? Is it reasonable that this consumer have been misled by this term? So now we are shifting and making the court asking complete different question. The court is asking if this carbon credit project was actually achieve what it claimed to achieve, if this area was suffer from deforestation, and if that area was reducing his biodiversity, and etc. So that's really raised the bar. So we saw that happening in 2025. Plaintiff firm incorporate those kind of evidence. But that did not happen in a vacuum, right? It's not just like a process that was happening overnight when plaintiff firm just decided to do that. This shift reflects a bigger shift that is happening in the world. And basically the ability to do climate intelligence and to turn environmental complex data into actionable insight has only recently become truly accessible. It's the result of major advancement, especially in the field of satellite imagery technology and AI, artificial intelligence. And if we're looking on only like 10 years ago or even less, satellite images of a given location might have been available only once a year, even so. Today, thanks to companies like Planet and to developments in satellite imagery technologies, we can access fresh satellite imagery of almost every point on Earth on daily basis. And this is crazy. This is crazy because it gives us tons of data to process, to interpret, and to have meaningful insight and information that can be taken from this. But access to data is not enough. That's where AI and machine learning comes in. These tools are what makes the data usable, even for people that are not scientists, even for legal teams. We use AI and machine learning to interpret these large data and to provide actionable insight from this. So in short, while technology has brought the data closer in much more volume, AI has made it understandable and usable. So yeah, what was once available only to scientists, maybe for governments, is now in the hands of also legal teams if they just want and choose to embrace that. And that's why climate intelligence is emerging right now. It's because for the first time, it's actually practical, and yes, for legal team as well. So yeah, at Darrow, we are very excited about climate intelligence, and we anticipate that the shift I was talking about will become more and more prominent, even so in the near future, and more plaintiff firms could hold corporate accountable for their green claims. That's it. Thanks, everyone. That was really great.
All right. Thank you, Noah. And thank you, John. We're going to move to Q&As. And the first question is going to be for you, John. How will these cases change the carbon offsetting market and carbon neutral representation more generally? And I think that it's really interesting to speak about this question in relation to the Apple case, which you mentioned.
Sure. I mean, I think it depends on the outcomes of the cases, right? If the Apple case gets past motion to dismiss, perhaps through summary judgment, or if there's a favorable settlement, I think that that will incentivize companies to more closely scrutinize the carbon credits that they're buying and using to offset their emissions. And I think that's a good thing. I mean, if companies actually do want to reduce their carbon footprint and be responsible stewards of the environment, then they should ensure and work with all the accrediting agencies and relevant stakeholders that what they're doing is actually effective. So I think this is actually aligning incentives here. We want the companies to care about sort of the guts underpinning their representations, and I think that cases like these would really make them start to pay attention.
Yeah, I think just thoughts. And again, speaking to my previous experience as an ESG attorney, I remember once a consultant told me, Amit, CO2 reduction is not easy. Don't treat it as such. And then you'll not be surprised. So I think that it's that mind shift that we're going to see through course as well. Now, the next question is for you. What other types of greenwashing litigation do you think will evolve in the near future with the help of climate intelligence?
All right, that's a cool one. Um, well, we talk about how AI has changed the game here and allowed to be the data more accessible and understandable. So if we compare carbon credits, evidence, climate intelligence data, we usually need environmental data on only one specific location around Earth and to evaluate and analyze that data. But if we look on supply chain events, for example, a company claiming all of our coffee is coming from deforestation-free sources, that's raised the bar to check much more places. So a company need, like usually will have thousands of farms working with across many different countries, and the ability to actually track each location and where this specific coffee is grown is basically impossible. But recently advancement in AI, specifically made by Google Geospatial Analytics team, has made it very accessible. They actually released open available data that identified different type of crops such as coffee and cocoa and bananas, stuff like that, and identified using artificial intelligence each location on Earth that those crops has been grown. And that's changing the game because a few months ago we couldn't identify, not a chance we could have identified the whole sources in the world that those crops are being grown on. But using Google and artificial intelligence, this is now possible. So just the only thing left for plaintiff firm is to connect the dots between a corporate to the sources, but the sources location we have. So I think the next soon wave of greenwashing litigation using climate intelligence will probably be supply chain litigation.
Interesting. Yeah, a lot of codependencies to get to a final product.
For sure.
Great. John, thank you. Noah, thank you. And to our audience, thank you for joining us. And if you have any questions, feedback, comments, we would love to hear them. We are contact@darrow.ai, and we hope to see you here on our next webinar. Thank you, everyone.
Thank you.
Bye.
Bye bye.